Dear viewers, Namaskar and greetings. This video is on judgments coming out during the fourth week of July. There have been some very important judgments which I'm sure will expand your knowledge. And we have tried out something new which possibly will interest you more. So, with this, I don't want to take a lot of time in the initial discussion. So, let me take you over to the next part of the video. You can see Guide to IBC on your screen. Now, let us first move to Section 1. Section 1 talks about short title, extent, and commencement. It says essentially that Insolvency Bankruptcy Code applies to extents to whole of India. Now, we have had one case. If we go to topics, we see that there was one case in IB code may be applied to foreign entities if they have presence in India. So let me do one thing in order to make sure that you understand. We are going to discuss about a case. So let me stop the screen share and do a screen share of the presentation which I have prepared for you. So we are talking of Section 1 topic. In 2019, a case took place, Excel Metal Processing Limited versus Benteler Trading, in which NCLT held that IB code may be applied to foreign entities if they have presence in India. Recently, that is of either of last Thursday or Friday, Supreme Court, in the matter of Hyatt International Southwest Asia Limited versus Additional Director of Income Tax, held certain very important judgment. Now, this is particularly important, though this does not apply to Insolvency Bankruptcy Code, but we know that cross-border insolvency is gaining importance. It's under the scanner of the legislature. Cross-border insolvency means what? It may be insolvency of an Indian company having presence in overseas countries, or it may refer to an overseas company of an overseas entity having presence in India. So this is cross-border insolvency. Now, with that, this particular judgment is of tremendous significance. You can see the highlights of this judgment. I have done it by way of a slide so that even on cell phone you can see that. Supreme Court held that the liaison offices are not permanent establishment. One of the sine qua non for a fixed place, PE, that is permanent establishment, is that the place through which the business is carried on must be at the disposal of the enterprise. This is called disposal test. Exclusive possession is not essential. Even temporary possession will suffice, provided it is established that business is carried on from this particular place. And once the continuity of business is established, intermittent presence and return doesn't make any difference. So this is a landmark judgment with regard to cross-border insolvency, which is under the consideration of the legislature. And with this, we move on to the next slide. We come to the next case of Jitendra Impex Private Limited versus Compact Enterprises Private Limited. This is a case under subsection 11 of section 3 of IBC. The topic is when there is no debt, there is no question of initiating CIRP proceedings. The highlights are when there is no debt, there is no question of initiating CIRP proceedings. The matter, this was an application under section 7, under section 9, in which there was a dispute between the operational creditor and the corporate debtor. The corporate debtor claimed that the operational creditor was allowing it quantity discount, which was negated by the operational creditor, stating that there was no specific agreement to that effect. the corporate debtors presented to the court 17 credit notes in which it was established, and out of which 8 credit notes were featuring in the books of operational creditor. It established that initially the operational creditor was giving it rupees 3 discount per kg discount, and later on they were giving a discount of 2 rupee 50 paise. So the claim of the corporate debtor was accepted. NCLT concluded that no amount above 22 lakhs 56,000 is due, whereas the operational creditor had claimed higher than 1 crore, but without considering these credit notes. So, and the corporate debtor offered to pay the entire amount. So, since he offered to pay the entire amount right there, NCLT held that when there is no debt, there is no question of CIRP proceedings. So the CIRP proceeding was cancelled. So with this, we move on to the next video. Next topic. The next topic is ARCL Organic Limited versus Stressed Asset Stabilization Fund. The topic is a financial creditor cannot assume unilateral powers to reopen issues which have been closed, especially having regard to the scheme of compromise being sanctioned by company court. This is a case pertaining to subsection 12 of section 3. In this particular case, what happened was there was a scheme under section 391 and 392 of Companies Act, which was approved by court, in which a company agreed to pay to the consortium of lenders. Now, one of the conditions was there was installments which were supposed to be paid, but there was one condition that allied resin, that is the corporate debtor, could pay the entire amount to one of the consortium members, and then they would resolve the issue. Now, they had paid the amount in 2000, and they had paid initially 20% amount on 14th of January 2009, and then subsequent payments were also being made. Stressed Asset Stabilization Fund instituted Section 7 proceedings against them. Now, the court held a financial creditor cannot assume unilateral powers to reopen issues which have been closed by company court through a proper judgment. And you can see the Section 34-35 SARFAESI Act cannot be construed to give unilateral powers to the respondent to reopen issues which have been closed, especially having regard to a scheme of compromise. The respondent, that is the Stressed Asset Stabilization Fund, was directed to issue no objection certificate and release all charges against the corporate debtor. So with this, we move on to next topic. This is a very important case. This pertains to subsection 27 of section 3. And it deals with margin money. So let us view the case. It is the case of Mr. Rajendra Prasad Tak versus Mahanadi Goldfield. The headline is the margin money is to be construed to be the money which has been deposited by way of a trust created to be paid to the beneficiary to whom the bank guarantee is given. Now, this case, as I said, this is of Chennai bench. This was a case moved by the liquidator. That is why you see section 35. Now, this is a case with what happened was a corporate debtor was proposing to have construct a power station, a power generating company rather. It had executed for that purpose, it had executed for Mahanadi Coalfield a performance bank guarantee. in which it also, when it's a coal-fired plant, so they have to take certain offtake. So for which a performance bank guarantee is given. The project did not materialize, and Mahanadi Coalfield invoked the bank guarantee. The liquidator, initially he was the RP, and when in liquidator said, okay, bank guarantee is gone. Performance bank guarantee does not come within the scope of insolvency bankruptcy code. We know that. But what about the margin money? It is the money of the corporate debtor. So return the margin money, which the bank declined. So NCLT held the margin money is an amount which is given for the purpose of a binding contract. It is a money extended as a security for the purpose of execution of a contract. The margin money is to be deducted from the price in the event the contract is executed and to be forfeited if the contract does not materialize or contract did not fructify. So it's a kind of a trust, and margin money cannot be refunded to the liquidator since he is deemed to be the original owner who does not have any vested right over the said asset unless it is made free from the trust which was created. So we have read about performance bank guarantee, but this deals with margin money and it clears a complete concept. So this is indeed important. So with this, we move on to next topic. Pertains to Form FA. It is pertinent with regard to Section 12A and 12A of IBC and Regulation 30A of CIRP regulations. It is the case of Messrs. SK Computers versus Mr. P. Madhusudan Reddy of Chennai NCLT. You can see the case on the website. Let us go to the slide. In this particular case, what happened was there was a Form FA submitted, which the corporator challenged. He went up to Supreme Court with the allegation that he had executed the Form A under duress, being compelled to do so, being coerced to do so. So Supreme Court directed NCLT to look into the matter. So after going through the case, the NCLT asserted that found that the corporate debtor had written to the Prime Minister's office on 12th of December 2024. Nothing happened thereon. And the settlement Form FA was executed on 2nd of January 2025. So this complaint was before filing of Form FA. And so the court held that the complaint which was submitted to Prime Minister's office happens to be prior to the time of the date of submission of application itself under Section 12A of IB Code. And besides, being a procedure unknown to law. Now, he executed Form FA on 2nd January 2025. And thereafter, he lodged a police complaint on 21st of January 2025. The charges which he brought, they required FAR being, the FIR being should have been issued by the police, which was not done. So the court held that it was the first time he had agitated this ground pertaining to commission of act of force, threat, and coercion of the respondent. Court did not agree to that, and they agreed the withdrawal of the CIRP proceedings. So with this, we take you to the next video or next topic. The next topic pertains to Regulation 36A of CIRP regulations. This is an important case. The case heading is case heading. Title is Mr. Gaurav Katiyar versus Nisas Finance. This deals with the threshold date for eligibility criteria. What happened was This was pertaining to a house building project in which the COC had specified certain eligibility criteria, and which was submitted. The case was contested by others. So let us take you to the main slide. The court held that the relevant threshold date regarding eligibility criteria is the date of submission of the resolution plan by RA in response to Form G. So on the date you submit the resolution plan, you have to meet the criteria. Now, there were two criteria. One was whether the RA had requisite experience of building, and they said that completion of building of 10 lakh square feet. Now, court checked into UP RERA and found that they do not qualify to have constructed 10 lakh square feet of super area. The next was the financial eligibility. The RA had submitted a letter from HDFC Bank stating that HDFC Bank was ready to put in 20 crores. Somebody had written a letter to HDFC, and HDFC Bank in reply stated that neither they had sanctioned, it was a sanction letter, nor it was a proposal or a document establishing disbursal of loan. So the RA was not considered to be meeting the eligibility criteria. But this is important. What is most important is the eligibility criteria has to be established on the date of submission of resolution plan. So with this, we take you to the next topic. We can see on screen the case of Orissa Metallics Private Limited versus Wilmenses. This is a case which relates to Regulation 39 of CIRP regulations and Section 30 also. So, and you can view the case here as well as in Section 30 also. But let me take you to the highlights. Now, in this particular case, what happened was the voting commenced. There were three resolution applicants. The COC decided that the voting would start on 22nd May 2024 and would continue up to 4th June 2024. In between, R3 emailed to RP stating that he wanted to withdraw from the process. But within 2 days, that was on 31st May, he again wrote a mail to RP stating that he wants to participate. He wants the RP to ignore his earlier communication, and he would like to participate in the process and would like to submit a resolution plan. And he moved an IA to the court also, mentioning that his offer is of 85 crores. Now, this matter, there was a question as to how, and what happened was COC in its meeting held that they're going to consider the resolution plan also moved by R3 as well. So the revised plan moved by R3 was considered. Now, NCLT held that if RFRP empowers, the COC may decide not to continue with the resolution plan submission process and engage in fresh negotiation with RAs. There is no impediment. And COC, through its commercial wisdom, decides upon the resolution, which resolution plan is to be approved. So this is absolutely COC's business. And there was nothing wrong because he had written a letter stating that the plan should be, he initially wanted to withdraw, but within 2 days he had written a letter, and he had also moved the R2 or the R1, the appellant, had offered in the revised resolution plan, offered 75 crores, whereas the R3 offered 85 crores, and he disclosed the 85, that he was offering 85 crores in the IA. So NCLT held that there is nothing wrong about it. But of course, the fact is, at the end of the day, what happened? They went in uh, for a Swiss challenge, and the appellant actually quoted 148 crores, and R3 quoted 156 crores. So ultimately, it went the other way. But whatever it is, the 39 regulation, this particular judgment is important because this deals with the nuances of RFRT. And also, this is there in topic 18, because which essentially says that COC, through its commercial wisdom, has the right to reject or approve resolution plan to the best, and it is not justiciable. So, with this, we move to the next topic. This is a case pertaining to uh, correction of an order of NCLT, and this is important. This is a small case, but very important case. You can see the case in the website, but I'm going to take you to the main highlights. In this particular case, it is Sandeep Goel versus a Anugram Builders. In this particular case, what happened was a resolution plan was approved. Subsequently, the RP moved a petition to NCLT for making some corrections to the order. It pertained to CIRP cost and so on and so forth. This application was moved after 3 months, so NCLT rejected the application. The matter went to NCLT, and NCLT held that rectification application should be made in form NCLT 9 as per sub-rule 1 of Rule 154 of NCLT rules, and can be made within 2 years from the date of the final order. IBC per se does not stipulate any time within which an adjudicating authority may be approached. This is provided in Rule 154 of NCLT rules. Now, this is a very, very important judgment. It's absolutely a technical point of view, and we should all be aware of this. So, with this, I take you to the next video, next topic. The next case, that is of G. Kalawati by death, with represented by legal representatives, versus G. Shashikala. She also is represented by legal representatives. It's a Supreme Court judgment. It doesn't pertain to insolvency bankruptcy code. But however, it deals with power of attorney holders. And in fact, this case is appearing, you will see it in the IBBI website also. So it's necessary. We see power of attorney often in insolvency bankruptcy matters. So this is an important thing we should know. The case details are available here. You can peruse them. But let me, in order to make you understand in quickly and in the summarized view. Now, what did the Supreme Court say? The power of attorney holder does not become an executant. He remains, the power of attorney holder remains an agent, executes and signs the agreement on behalf of the principal. So he is never the executant. The executant is the person in whose name the thing is being a deed or whatever contract the power of attorney holder is signing. Now, what is most important is registering officer should satisfy himself as to the identity of the party with left thumb impression as well as signature of the power of attorney holder. Even if a power of attorney is registered, it would not be valid for registration purpose unless the power of attorney holder is authenticated by the registering officer. So this is important. And with this, we should keep this in mind because we often, I mean, all Section 7 petitions are moved by authorized representatives. We see, and especially with personal guarantors coming, there are cases in which personal guarantors, the resolution, the bankruptcy trustee may have to deal with cases of personal guarantors who have passed away. So in such cases, the power of attorney holders will become important. So this needs to be, we need to keep a note of this. With this, I take you to the next topic. We come to the most important case of this particular presentation. This case is of Vishnu Vardhan versus State of Uttar Pradesh. It's a judgment of Supreme Court. This also doesn't deal with insolvency bankruptcy code, but gives a fabulous judgment on what fraud is and what is the viewpoint of the court with regard to fraud. You will find this case in both in section 62 as well as section 67. The case details are here available, and even in 67 also it is there. So let me take you to the highlights. In highlights, the court has stated simply nothing and nothing is obtained by fraud. Nothing can be sustained as fraud unravels everything. The court held that fraud and justice cannot dwell together. If fraud is proved, even finality of litigation cannot be pressed into service to absurd limits when fraud is unraveled. Court also noted that there is a growing trend of abuse of the process of law by dishonest litigants playing fraud on courts. Court also noted that post 1970, I mean, since 1970, the interpretation of Constitution, particularly fundamental rights, it has taken a significant transformation. There are multiple judgments which have has been delivered by Supreme Court and other courts, which has criticized the government also and establishes the fundamental rights which has been embedded in the Constitution. Court has stated that procedural law cannot foresee all situations that may arise, but procedure must facilitate justice, not detract from it. The courts are duty-bound to apply procedural law in its entirety, save where such application would result in manifest absurdity. So we get a very clear view of the approach of the court pertaining to fraud. And especially, this is especially important as far as insolvency and bankruptcy code. And we should, as insolvency professionals or lawyers or whatever it may be, we should be aware of this. So with this, we move to the next topic. We come to section 94. We come to insolvency of individuals or personal guarantors. Now, we know section 94 deals with insolvency petition moved by the guarantor himself. Now, this case is of Mr. Saurav Prem Prakash Chuk versus State Bank of India, in which Section 94, the court held that Section 94 petition cannot be moved, cannot be entertained when the proceedings were initiated not with the intent of genuine insolvency resolution. You will find the details of the case here. Let me take you to the highlights. Now, this particular application was moved by, this is the second time the personal guarantor approached the court. His earlier application was rejected. And this application was rejected also on the ground that earlier application was rejected. The lawyer representing the personal guarantor said that there was typing error, so the court should not have rejected it. This matter deals with uh, a personal guarantee executed by the guarantor, and wherein the bank has sent demand notice and also notice of taking possession since 2017. So, in order to avoid uh, the proceedings of taking possession of the property, the guarantor moved a 94 petition earlier also, which was rejected. And in the second time, he moved a proceeding. So the the court held when the earlier application was dismissed on merits by order on 9th January 2000, well, 9th January 2025, it was not open for the appellant to file fresh application under Section 94 because it'll be hit by the principles of res judicata. Correction of any typographical error in the application by filing fresh application filed by appellant is inconsequential. Consequential. As I told you, the applicant had made inconsistencies in the application. He had suppressed the fact of invocation of guarantee. He had given contradictory dates, and all this, and he had earlier application was moved on and rejected on in 2024 December. And as I said, the notice of taking possession and things had come in 2017. So this application was moved essentially to avail the interim moratorium. Court could see through it and rejected the insolvency petition. So with this, we take you to another case, which is at Section 95. This is an important case in Section 95. We know that the Limitation Act applies to insolvency and bankruptcy code, and also pertaining to with regard to insolvency of personal guarantors. In 95 or 94, Limitation Act would play. But this case is important because in this NCLT, Honorable NCLT held that referred to the judgment of Apex Court in Dena Bank case and held that recovery certificate gives rise to fresh cause of action. The cases of Mr. V. Anjaya versus Prithvi Asset Reconstruction. The detailed judgment is here, but let me take you to the highlights. In this case, what happened was the financial creditor had moved a Section 95 petition, which was rejected on 29/12/2021 because of non-service, which was absolutely a technical issue. And financial creditor moved the petition again and issued a fresh demand notice, embodying the same default and other things. And obviously, the personal guarantor objected to the fresh demand notice being issued. The court held that issuance of fresh notice was not the object of or the intention of the order of NCLT dated 25/5/2023. Since the notice of demand dated 29/12/2021 was admittedly served on 18/4/2023 and the proceeding was initiated on 5/7/2023, the same would not be barred by limitation. Why? The period of 3 years would be computed after excluding COVID-19 period because of suo motu judgment of NCLT. But in between, on 9/7/2019, the court had issued a debt recovery certificate. Now, in Dena Bank judgment, Apex Court held that debt recovery certificate issued would give rise to fresh cause of action. So the 3 years limitation period would start from 9/7/2019, which would end on 8/7/2022. But in between, there was a COVID-19 period, which has to be excluded. So even if it was moved in May 2023, there was nothing wrong about it. So this case is important. And you will find this case also in 238A as well in topic 2.
Dear viewers, we have come to the end of our podcast. As always, I would request you to please comment on our video so that we can know what you are liking, and if you are disliking something, please let us know. Furthermore, I'll be very happy if you will share our videos with your friends and fellow professionals or relatives, and subscribe to our channel, and also visit our website. Thank you so much. Bye for now.